Welcome to the deep dive. Sometimes it feels like you're drowning in news about legal changes, consumer rights, job issues. It's just a lot. It can be really hard to figure out what actually matters to you. So today, we're cutting through the noise. We've dug into a really significant 2025 Supreme Court decision. It touches on product labels, corporate honesty, and maybe even your job security. We're doing a deep dive into medical marijuana Inc., et al. V. Horn. Now, the name sounds technical, I know, but it boils down to a very real question. Let's say you suffer a financial loss, lose your job, lose business because of something that first caused a physical injury, maybe a defective product. Can you still sue for triple damages under that big federal law, civil RIC?
That's exactly it. That's the mission today. We're basically following the story of Douglas Horn. He was a commercial truck driver.
Yeah.
And his situation, honestly, it perfectly highlights how a seemingly small choice, using a product advertised one way, specifically as THC-free, can spiral. It can spiral into this huge legal fight that actually redefines a major federal law.
And yet, when we talk triple damages, that's the Racketeer Influenced and Corrupt Organizations Act, RCO. You hear about it with organized crime, right? But it's also used now for things like systematic fraud, like, say, false advertising over mail or online. And the stakes here are huge because this decision could potentially open the door for a lot more lawsuits, maybe turning everyday injury claims into these high-stakes federal fraud cases.
Definitely. It's a big deal.
So let's start with the person at the center of it all.
Okay, Douglas Horn. So he wasn't trying to get high or anything like that. He was looking for pain relief. He'd been in a truck accident back in 2012, left him with chronic back and shoulder pain. So he tries this product, Dixie X. It's a CBD tincture. And the big selling point for him, especially being a trucker under federal rules, was the company saying it was CBD rich, non-psychoactive, and this is key, 0% THC. Guaranteed.
And he didn't just take their word for it from the label, did he? I mean, our sources say he actually called customer service to double check, is this safe? Is this legal for my job?
He really did his due diligence, as much as you reasonably could expect. But, well, the guarantee didn't hold up. He gets picked for a random drug test, and he tests positive for THC.
Oh, wow. So then what?
His employer gives him a choice. Go into a substance abuse program, or you're fired. He refused the program. He argued, look, doing that would basically be admitting I knowingly used illegal drugs, and I absolutely did not. He stood his ground on that.
And the consequence?
He lost his job.
Yeah.
So the injury he sued over in his RICO case wasn't like the physical effect of the THC. It wasn't pain and suffering. It was the direct financial hit, losing his employment.
Yeah.
That loss, that's what he claimed as the injury to his business or property under RICO.
Okay, let's quickly define RICO again, just simply. It's 18 U.S.C. Section 1964. It says anyone injured in his business or property because of a violation like the mail fraud or wire fraud, Horn alleged with the false advertising, can sue. And they can sue for threefold the damages he sustains. Triple damages. That's the kicker that makes companies really nervous.
Right. But there's a really important limitation here, and everyone agrees on this part. RICO doesn't cover purely personal injuries. Things like physical harm, pain, suffering, emotional distress. You can't get RICO damages for those. It has to be business or property loss.
So the whole fight, the reason it went all the way to the Supreme Court, was about this connection, right?
Yeah.
Did Horn's lost job, clearly a business or property loss, come directly from what the company called an antecedent personal injury, meaning the THC ingestion? And if it did, should that connection block his RICO claim entirely?
Exactly. That's the nub of it. Horn said, look, the THC getting into my system was just the unavoidable trigger for the real harm, the economic harm. Medical Marijuana Inc. argued, no, you can't separate them. The lost job flows directly from the physical event, the THC ingestion. So the whole claim is barred.
This is that antecedent personal injury bar concept.
Precisely. If that bar exists and applies, Horn loses. If it doesn't apply, well, that potentially creates a lot of new legal risk for companies making product claims.
And this wasn't just a theoretical debate. The lower courts were completely split on this, right? It actually mattered where you filed your lawsuit.
Oh, absolutely. A classic circuit split. You had the 6th, 7th, and 11th Circuit saying, yes, this bar exists. If Horn sued there, case dismissed. But the 2nd Circuit, looking at his specific case, disagreed. They overturned the initial district court ruling. They explicitly said, no, there's no such automatic bar just because a personal injury happened first. They agreed with the 9th Circuit. They basically said Horn was injured in his business, he lost his job, and that's what matters for RICO, regardless of the THC part.
You can see why businesses were watching this so closely. If the 2nd Circuit's view held, any consumer who felt misled by advertising, and maybe suffered some minor physical effect but then lost wages or something, could potentially bring a federal RICO case for triple damages.
That was the fear, definitely. Which brings us to the Supreme Court's decision. It was close, 5-4. Justice Barrett wrote the majority opinion. And they sided with the Second Circuit. They said no. Civil RICO does not automatically bar recovery for a business or property loss just because it came after a personal injury.
Okay, this is the crucial part. Let's break down how the majority justified this. How do they legally separate the physical cause, the THC, from the economic harm, the lost job?
They went back to the text of the law itself, specifically the word injure. They looked at regular dictionaries, not just legal ones, and said, look, the ordinary meaning of injure is simply to cause harm or damage to, or to hurt. They argued Congress meant that broad, everyday meaning, not some specialized legal definition.
So they rejected the idea that injure is some kind of legal code word, a term of art, tied only to violating a specific legal right.
Exactly. The petitioners, the company, argued for that term of art meaning, which the dissent agreed with. But the majority said no, let's stick with the plain meaning. And if you do that, the focus shifts. It shifts to the kind of harm you're claiming damages for. Is it business or property? Not what originally caused that harm down the line.
So basically, for a RICO claim, you look at the end result. Was there a financial loss? If yes, you don't necessarily get blocked just because a physical event started the chain reaction.
That's the essence of it. And the court gave a really helpful analogy to make this clear. Think about a gas station owner. Let's say robbers beat him up during a robbery. That's a personal injury. He can't sue under ICOCO for his physical pain, his suffering. That's barred.
Okay, makes sense.
But if those injuries are so bad, he has to shut down the gas station. Maybe fire employees, sell the place at a loss.
Ah, that's the business or property loss.
Correct. The robbery, the physical assault, was the catalyst. But the recoverable harm under RICO, according to the majority, is the loss of the business itself. So the fact that a physical event happened first doesn't taint or disqualify the later economic claim. It separates the type of loss from the type of cause.
That seems pretty clear when you put it like that. But there was a strong dissent, wasn't there? Justice Kavanaugh led that. What was their big concern?
Their main worry was about federal courts overstepping into areas usually handled by state law. They really pushed back on the majority's reading of injured. They insisted injured is a common law term of art. It means the invasion of a legal right. Under that view, when Horn ingested the THC, that was the primary injury, the invasion of his bodily integrity. And since that's a personal injury, it's not recoverable under RICO.
So what about the lost wages then?
The dissent would say the lost wages, or even medical bills if he had them, aren't a separate injury to business or property. They're just damages. They're financial consequences flowing from the primary personal injury, which itself isn't covered by RICO.
Ah, okay. That's a subtle but really critical legal distinction. Injury versus damages.
Absolutely critical to their argument. And their big fear was practical. If Horn's lost job is seen as a separate property injury, then couldn't basically any plaintiff in a standard state-level personal injury case, think car accidents, defective products, pollution, who also lost wages, couldn't they just relabel their state claim as a federal RICO fraud case against the company involved, hoping for those triple damages?
Yeah, that would fundamentally change the landscape for businesses. A state lawsuit for lost wages after an injury is one thing. A federal RICO suit with potential treble damages, that's a whole different level of risk. Could be devastating.
Precisely. The dissent warned this ruling could effectively federalize huge chunks of traditional state tort law. Product liability, environmental torts, everything. They pointed out how hard it is to draw a consistent line. Why is physical assault causing emotional distress barred by RICO, but in the majority view, an assault causing you to lose a business deal might be allowed? It gets tricky.
And the majority did acknowledge it's not always simple, right? They mentioned cases like using violence to get a password to drain a bank account.
Yes, or paying a ransom after a kidnapping. Both involve personal harm leading directly to a clear financial loss. The majority stance seems to be, if the ultimate loss you're claiming is economic, the business, the job, the money, it potentially fits under RICO's business or property language. Whether violence or accidental ingestion got you there is sort of secondary to the nature of the final loss.
Okay, so Horn won a major battle here. The court removed this antecedent personal injury bar. That's huge, but as you read through the analysis, it's clear this isn't the end of the story for him or for future plaintiffs. There's still a big hurdle. the direct relationship requirement.
That's absolutely right. That's the big catch, and it's still very much in play. To win a RICO case, your injury must be by reason of the defendant's violation. And the Supreme Court has consistently said this means there needs to be a direct relationship. It can't just be a foreseeable consequence somewhere down a long chain of events. It has to be direct.
Okay, let's focus on that for a second. What does direct relationship mean for Horn specifically?
Well, Horn has to prove that the company's misrepresentation, that 0% THC claim, was the direct cause of him losing his job. But think about the steps involved. The company makes the claim, Horn buys and uses the product. He fails a drug test, his employer offers rehab, he refuses his say, he gets fired. You see, there are several steps between the initial alleged fraud and the final job loss.
Yeah, the drug test itself and then the employer's decision based on his refusal of the program, those seem like intervening factors.
Exactly. And the Supreme Court actually flagged this in the opinion. They specifically noted that this directness requirement might be an insurmountable obstacle for Horn when this case goes back to the lower courts. You have to show the false advertising wasn't just the first domino, but that it was so fundamentally linked to the firing that the firing was a direct result, not just an indirect ripple effect.
So wow, even after winning at the Supreme Court on the antecedent injury issue, he still has a really tough path ahead to actually win his case and get damages.
A very tough path. The bar is gone, but the causation hurdle remains very high.
And on top of that, the court actually left a few other key questions unresolved, didn't they? They kicked some cans down the road for lower courts.
They did. For one, they never officially decided if Horn actually suffered a personal injury from the THC. They just assumed he did, for the sake of the legal argument about the bar. Second, they didn't definitively say if the term business in RICO always covers someone's employment, like lost wages or the job itself, or if it's more limited to owning an actual business.
And the big one, maybe. What about injured in his property? Does that cover all financial losses, like medical expenses?
Right. They didn't settle that. And if the answer to that last question turns out to be yes, then the dissent's warning about repackaging state tort claims as federal RICO cases starts to look much more plausible.
So a lot still up in the air.
Definitely. The court was pretty open about it. Justice Barrett wrote that civil RICO has clearly evolved into something quite different from the original conception. They basically said, look, if this interpretation leads to too many RICO lawsuits, it's really up to Congress to step in and change the law. The court interpreted the text as written. Fixing policy consequences is Congress's job.
Okay, so let's try to summarize the main takeaway from this deep dive for everyone listening. It seems the Supreme Court really clarified one key point. When you're looking at RICO, you focus on the type of harm suffered at the end. Is it financial damage to business or property? If yes, that claim isn't automatically blocked just because a non-recoverable physical event happened earlier in the chain.
That's the core principle affirmed here. And the implication is significant. Companies making claims about their products, especially health or safety claims, now face a potentially higher risk profile. The threat of federal court and triple damages for resulting economic losses, like a lost job, is more real now. The door is open wider, you could say. But, and it's a big but, the plaintiff still has to prove that very strong, very direct connection between the company's misconduct and their financial loss. That's still the really hard part.
A really complex decision with far-reaching potential consequences. It makes you wonder, if Congress does try to address the dissent's concerns about federalizing state law, how could they possibly write a law that narrows RICO to exclude these kinds of economic losses following personal injuries without also accidentally creating loopholes that protect actual organized crime? That seems incredibly difficult. And for you, listening at home, maybe think about this. If you were in Horn's shoes, lost your job because you trusted a product label that turned out to be wrong, would that lost career feel like an injury to your property or just incredibly bad luck? Something to think about as this area of law continues to develop. Thanks for diving deep with us today.